Welcome to HR Success Talk, a global platform of over 150,000 HR professionals and business leaders, with a presence in 11 countries including India, the UAE, USA, Ghana, Saudi Arabia, the United Kingdom, and more. We believe in creating exceptional workplaces through collaboration, learning, and meaningful conversations that drive growth. HR Success Talk is built on a simple idea: growing together. Here, you grow professionally while helping others grow. Build connections for networking, career advancement, business collaborations, and mentorship. With more than 70,000 followers on Facebook, 29,000 on LinkedIn, 60,000 plus active website users, and 36 plus WhatsApp groups, we ensure you're always part of the conversation. Our events are designed to bring people together through both offline and virtual formats. Offline events include HR conferences, conclaves, roundtables, and workshops, designed for in-depth learning and face-to-face collaboration. Our virtual events include webinars, online HR meets, and talk shows, bringing accessible insights right to your screen. HRST Elite Club is an exclusive community of senior HR and business leaders from key cities. These are focused, closed-door sessions for strategic leadership exchange and real-world problem-solving. Through our Future Leaders Club, we prepare emerging professionals to take on leadership roles by offering mentorship, structured learning, and networking. With over 250 HR meets, strong media recognition, and a global volunteer network, HR Success Talk is helping shape the future of HR and business. Whether you're a leader, learner, student, or mentor, there's a place for you at HR Success Talk. To get involved, write to us at deept.karana@hrsuccesstalk.com or visit www.hrsuccesstalk.com.
Good evening to everyone, and welcome to one of the exclusive webinar that we are going to do on the recent labor law and codes that have been introduced by Government of India. This is something that many WhatsApp group are flooding with. A lot of people are asking a lot of questions around it. The news channels are featuring it. There are a lot of confusion among people. We have some half-cooked information coming from different media channels right now. And even the social media, there are a lot of posts that are talking about this. So we at HR Success Talk thought that it will be a good idea to have a webinar where we are basically going to take major questions that coming to your mind is HR leaders and tackle them one by one. And why only questions that we want to talk is because we all are getting a lot of information. So I'm sure at this point in time, many of us are aware about the key highlights of the changes that are expected to come. But there are many questions that we have that we need to ask. And for that, we definitely look up to some experts here. And today, we have invited Radha Krishna Murthy with us, who is basically a legal corporate advocate and serving diverse industry from IT, ITS, manufacturing, etc. And he has been also one of the key speaker in the HR Success Talk Labor Law playlist. So if you have never seen him in our playlist in YouTube, now is the time for you to have interaction with him. So first of all, welcome RK on the show. You can unmute yourself.
Thank you, Mr. Govind, and thanks for the HR Success Talk. And during the COVID time, we did many sessions periodically at that point of time. Now it is the topic of the hour and the need of the hour as well, the new changes and the labor codes and other things. And as you have rightly put it, in the media, they are giving different versions. Morely, some are apprehensive, some are myth, and some is the reality. In fact, when we thought of making a comprehensive presentation about all four codes, we thought due to the paucity of time and within the span of 1.5 hours, we would not be able to complete it because we always believe in accomplishment than completion. So if we put in the if we put in the Q&A, we will be answering the doubts of the participants. So each participants who are active in raising the query will have a takeaway at the end of the session because the
Yeah.
doubt is cleared. And after my clarification of the doubts and after answering these queries also, if they do have any still clarification, they can put it in the box and Mr. Govind definitely would moderate the same and I would be able to answer it.
Right.
Now, going forward for this on the topic, briefly I will give an introduction. The main topic that is concerning mostly the IT, ITES, which is a common for the whether it's a core sector or a IT or ITES or whatever it is. Compensation benefits, pay package, salary is the common one. So in this, there is sort of fear, apprehension that the cost is going to increase and the companies has to incur additional expenditure on account of the fixation of basic at the ratio of 50-50, the allowances should not cross 50 and all. Now we'll focus on the salary structure. Basically, as per law, different companies have evolved or introduced policies inviting several allowances as part of the salary. Let me say that the scales of payment are originally originated from the public sector or the government because they have set of rules because they cannot give increments, there will not be perfect performance appraisal, so on and so forth, unless. So the private sector, none of the provisions of the labor laws or even the present new wage code say that what there should be a scale of pay and other things also. No code at the present, even the wage code or any other labor codes or the former earlier enactments, they don't say the the allowances, various parts of the allowances. So allowances are invented basically initially to plan the tax because certain allowances are not attracted tax at that point. Who are in the higher bracket and the income tax bracket, now the allowances, everything is taxable by virtue of the amendment. In view of that amendment, only the reimbursement is an exemption. So, in such event, the allowance only is a fashion word, but not the legal word. What I can say, it is rather called as a management word. Another thing is that mostly the employers, what I have been seeing, they'll be while acquisition of the talent acquisition and attracting the talent in the negotiations, the pay pack, they will put certain things which are being annually paid are statutorily otherwise to be paid as annual package. The annual package consists of the gratuity, which is a contingency, and recently there is also a judgment that the gratuity shown in the annually payable that will not be treated as a gratuity as against the statutory gratuity that is to be payable. That one has to make note of it. And another thing is that the leave encashment and other things they will be calculating. Another thing is the performance bonus also they will be paying. So that is not all the performance bonus also ambiguity. You will be paid performance bonus up to 1 lakh, up to 2 lakh. There is no parameter how the 2 lakh is assessed. There are also so many disputes are arising out of that. Another thing. So here when you come to the wage code, what is the thing impact? Earlier, because each one has to put his own basic wage, some used to put 20%, right? Some used to some rational, some irrational, some 30%, 40%, 50%. So, but mostly it would have been 40%, not more than that. But I say it is mostly they think that enhancement of basic and defining the basic wage is a bane. That's what the employers are thinking. But I always say boon. Why I call it as a boon? Because earlier, because whenever the PF inspects saying that you are not properly paying the bonus, the basic you have reduced, and this allowance is part of the basic wage, that allowance is a part of the basic wage, and so many disputes, 7-year inquiry, then the damages under 14B, interest under 7Q of the former act. So this is what is happening. Now, no PF enforcement authority can say when you have to mandatorily maintain 50%, and when you are paying 50%, there can't be any dispute in respect of the contributions because it is mandatory 50%. So another thing is that PF liability is to be going to be increased. That is what mostly do. What I mean to say, as per the PF Act, even in the new Act, this is the new old wine in the new bottle. There is no change as per the PF coverage is concerned, as per the eligibility for payment of PF, and it is maximum cap is 15,000 rupees. If any employee whose basic wages crosses more than 15,000 rupees, there is no obligation on the part of the employer to make contribution over and above the residual amount of 15,000 rupees basic, because there is no such obligation. So how can we say that there will be an impact and it is having a until unless you pay higher contribution? Higher contribution is an option, but it is not mandatory. So according to the costing or the budget which you would be projecting for the next year in respect of the pay and allowances and wages and salaries, you can reorganize it in such a manner it will not have an adverse impact on your costing. So I think 15,000 is the ceiling. Then coming to the another thing is that suppose there is also another query that has been raised in the questions. Suppose in the event if the employee crosses the basic wage of the employee crosses more than 15,000, by default his PF ceases to apply. No, he once a member continues to be a member for hour and your liability is only freezed to 15,000 irrespective of the basic whether it is 20,000 or 30,000 or whatever it is. Then so even that way also there will not be much of impact. Nowadays you see 15,000 who is drawing. Even if IT, industries, you take the lowest paid employee starts at 30K minimum, the bare minimum, or 40K, 50K. I think it will not have any impact. Even in the blue collar employees, in many of the states, now they are going to also decide the floor wage as the base for the minimum wage, and any minimum wage that is going to be fixed by the respective state government should not be less than the floor wage. It would also, I think, probably touch 20K or something now. So that is another aspect. So when it is mostly for the blue collar employees, there may be an impact who is drawing less than the basic wage and other things, and especially the workman category. That is one aspect. Then coming to the ESA, ESA is the gross wage. Whether you add it allowances or basic comes up to applicable only up to 21,000. The moment they cross the magic figure of 21,000, there is no impact. So anyway, gross wage is taken. In what way this 50% basic wage affects? Normally in the TV, in the media, what I mean to say, they will be giving the breaking news that it is going to shoot up employers' cost. I don't know whether cost shoots up or not. The employer's BP would definitely shoot it up by hearing this, by
Yeah.
hearing this breaking news. Another thing coming to the point that is the ESA and that is the yes, Mr. Govind, you want to ask something?
Yeah, what I wanted to say is that first of all, there are a lot that is going on, and I think I would love to make it more like one taking one question at one point in time, because I already see that a lot of our audience is putting a lot of questions on the comment, and I think it will be easier for all of us to take one question, understand it, and then move to our next question. And I'm sure during this process, all those questions will be like I'm sure all the questions that our audience is asking will be answered automatically. So that's one. But first of all, thank you very much, RK, for setting the base for our audience at this point in time, and at least so that they are aware. So that's great. So, and once again, welcome to our show. And what I would say is that before we go into the question and answer mode, our audience knows that while we are
No,
registering,
I'm sorry. How many we now so far joined, Mr. Govind?
how many are live is what you're asking, Mr.
Yeah.
RK. I can see on LinkedIn there are 170 people live, but there are other
Oh,
platforms like YouTube and other where I see many other people might be there. So it's a distributed audience that is joining on LinkedIn, YouTube, and Facebook.
okay.
Now, going back to what I was saying is that our audience has, while registering for this particular webinar, they actually asked some questions from us that they wanted us to ask from you. And we actually created a list of those questions. So first of all, what are we going to do is We're going to try to clear those questions and then go to our audience questions and see if there are questions that are left out that we did not answer.
Perfect.
Um, but before we go to that, to our audience who are already part of the WhatsApp group for this particular webinar and who have joined us live at this point in time, I wanted to tell that we are going to distribute certificates to all of you for participating in this webinar. And for that, we have a form that you can fill. If you see on the top right at this point in time, there is a barcode that is flashing, and you can definitely use that barcode to mark your attendance. Just scan the barcode. It will take you to the Google form, and from there you can mark your attendance. Whosoever will be marking their attendance, our team will be issuing a certificate to you after the webinar is over. So just want to tell you, I'll keep this barcode on the screen for a while, and people, please feel free to scan it and mark your attendance for the certification. Now, RK, let's move to the one by one question and try to answer those questions. And we have a huge list of the questions, RK, and we have almost 1 hour, 15 minutes only to answer all of them. And then we have audience questions as well. So let's start with the first question. And I would request if you can be to the point on the scripts so that people understand what you want to say. But I'm sure there's a lot of follow-up questions on that. Are you okay if I flash the first
Yes,
question on the screen?
yes, yes, yes.
So here's the first question, RK, on your screen at this point in time. And the question is, if PF contribution on other allowances excluding HRA to the extent of 15,000 continuing per earlier Supreme Court judgment. Over to you.
No, the thing, but we will not bother about which allowance is part of the basic wage, which will not be come under the basic wage, because now this 50% cap is there. Any allowance, it whatever nomenclature you pay it, total out of the total salary, if there is any deficit in the 50% of the basic, the remaining allowances has to be treated as basic wage, and the demand of the contribution, the liability of the contribution is on the 50% of the total wage is the basic wage.
Okay, so just to make sure that we have a clear understanding, there was something that was said, and I see some questions around it also. And it says that the basic has to be 50%. So, RK, is it that 50% of what? Is it 50% of the gross? Is it 50% of the CTC? That should be there.
No, there are certain exemptions under the PA, this wage definition, because the contribution paid towards the PF will not be, because gross means usually the CTC, cost to the company, that will not be taken into account, and the contribution paid to the ESI, that will also be not to be taken into account, or there is a retaining allowance that can be treated as this thing, so it will not be, but only that wage total, barring these exclusions, barring these exemptions, the remaining is the wage, that is the thing. But exemptions are very one or two items only, not much. So by and large, you have to blindly fix in mind that is 50%.
That's great. I think this was one of the things, and thank you very much for answering this question. The other question that we have, RK, it says any changes in limits specified for PF and ESI, like that ESI is on 21 gross. Is there any change there, or there is no change on that?
No, it is the same. The 15,000 cap is as it is. There is no change. And the ESI 21,000 is also change. There is the same thing. There is no change in it. And as I said right now, that there is no liability for payment of contributions on above 15 until unless the employer and employee opt for the higher contribution.
Yeah. So basically, the existing provident fund rules are not changing, right? It
Yes.
stays the same. You have to follow the same. It's not that you are making your basic 50%, so you need to pay PF on 50%. It depends upon what is the policy that you have applied, whether you are capping it on a limit or you are not capping it on limit. Is that correct
I'll
understanding?
I'll put it this way. Say, for example, my basic is 30K, be it a
Okay.
dearness allowance or whatever it is, my 30K. Whereas there is no higher pension contribution, it is not been committed. So the moment my liability is confined only for 15K.
Got it.
So it can't be said my salary is, say, my basic is 30, my salary is 60, 50% of 60 comes to 30. I need not be beyond 30 because the liability of 15 only, until unless I voluntarily invite as an employer or an employee.
Got your point. Okay. So we'll move to another one. And this is again, because we are taking all the Provident Fund questions at this point in time.
Yeah.
Okay, we'll move to another section. Can PF be exempted where basic is above 15K, or PF contribution applicable across all the categories?
Yeah, PF is, you can't say that by default, the moment the basic wage crosses 15K, PF ceases to apply. PF continues to apply, but the liability for payment of contribution freezes to 15K.
And again, the same thing. It is the
Suppose,
new.
I'll just add it. Suppose if the employee is not a member of PF at the time he joins in the service and his basic wage is more than 15K, then
Then
he
you can.
need not be covered.
Yeah. And again, the same thing I would say here is that there's no change by the new the labor code here on the existing Provident Fund. You have to follow the same rules that are already there, right?
Yes.
Okay. I'm moving to another one, and this is more general question: that is there any change in the PF wages as per the new code, or is it the same? Nothing changes there.
No, only they say that it is 50% is universally one has to apply. Earlier, each one has to put their own basic, be it a 20% or 30%, something like that, their own basic they used to put. Now they can't put like that, it is the 50%. But the liability again, 15K only.
Got it. Similar but little different is the impact of the PF on all the categories of the contribution. Do you see any impact because of the wage code coming in, or it remains the same? No impact.
I don't think there is an impact. Why? Because I am saying, because once we are contributing on the actual basic, opting for the higher contribution only, there is an impact because basic shoots from 30 or 40 or whatever it is, as the case may be, to 50%. Otherwise, when you are confining only 15, the increase in the basic will have hardly any impact.
Makes sense. Well, these are some of the questions around Provident Fund and other Social Security that we could gather from our audience that participated in this one. Now, before I jump to the other category of the questions, I would like to remind all our audience that they can definitely go to the barcode that is there on the top right and scan and put their attendance there to get the certificate. So that's one thing I would say. Now, moving back to the questions, and I'm moving to the gratuity question because there are a lot of rumor going around about gratuity at this point in time. And the first question is about the eligibility of the gratuity between FTE and permanent employee. I think the question is more about a contractual employee and permanent employee. So I know there are a lot of questions around that. Would you throw some light on this, RK?
Yes, certainly. Because what is the now the new provision that is introduced in the new enactment? Earlier, the gratuity the employee is eligible only when he completes 5 years of service in an organization. Now, what they said is that they have also introduced a concept of FTC, fixed term contract employment. Here, one
Hmm.
has to remind that it is not a contract labor; it is a contractual appointment. Contract labor is an employment where the person is employed by a third party and supplied to the principal employer's establishment. Then the question comes, and the ambiguity and the confusion among many of the professionals is that whether this 1 year gratuity, as per the fixed term contract, if he puts in 1 year of service without waiting for 5 years, he is entitled for gratuity. Then let me also furthermore detail explain about it. Because why they have put it is, fixed term contract is a contingency one, uncertainty, and suppose if he works for 2 years, it is not that he is leaving, whereas we are putting an end to him. There is no fault of the employee. In such event, legislature wisely thought that they be compensated by virtue of the gratuity for the service what they have put in. It is not that they fixed their service; it is the employer who fixed their service. That is the reason. Again, most of the confusion is that For contract labor also, does the employer has to pay for 1 year if the contract labor complete? No, contract labor is different. Contractual employment is different. That contract labor is a contract for service. It is a contract of service. So for that, for us, he is a contract labor. For the establishment of the labor contracting firm, he is a regular employee. So he will be getting the gratuity only when he puts in 5 years of service. You have to load that expenditure for computation, but it will not happen. Another thing is that what is the cost impact of it, whether the additional burden on the employer by virtue of this 50% basic, because gratuity to be paid on the 50%. Yes,
Right.
certainly, but also not unlimited burden, because the gratuity ceiling cap is only up to 20 lakhs. Beyond 20 lakhs, there is no obligation. If any employee's gratuity crosses, otherwise, generally, the slight burden will be there on payment of gratuity in view of the. Similarly, with the bonus also, because bonus also, it cannot be said there is an unlimited liability. The employees whose basic and dearness allowance drawing up to 21,000 only are covered under the bonus act. The moment they cross, there is no impact on the bonus as well, the basic enhancement.
Got your point. Awesome. I see a lot of other questions on gratuity, but they are very similar to what you have answered. But I'll still put on the screen just to make sure that our audience get more clarity on that. Is
Yeah, this has
gratuity
been
payable
answered.
after 1 year of a completion? What you're saying is that it is applicable only when in case of the contractual employees as opposed to a permanent employee. A permanent employee still will be following the old rule of gratuity. Is that correct?
Yes, 5 years they have to complete it.
Okay.
Because
Now,
simple logic is the permanent employee leaving at his option. Contractual employee is leaving by the deadline put by the employer.
yeah. And Vishal is also asking a question from our LinkedIn Live. He's saying, is revised gratuity rule is applicable to regular employees? Which is not actually. The regular employees or the permanent employees will have to follow the same 5 years rule. Vishal Watikar on the screen right now, I could see. I just saw this comment and I just put it there. There's another thing is called gratuity applicability for contractual employees and fixed term contract. Is there a difference between a contractual employee and a fixed term contracts, RK?
No, there is a contract labor and employee and contractual employment. The contract labor is employed to a third party, labor
Mm-hmm.
contracting firm, and supplied to us. So there is no 1 year payment gratuity for the contract labor engaged under this Contract Labor Regulation and Abolition Act under the New York this thing. No issue, because they are the permanent employees for the contractor's establishment. They can deploy them anywhere to any of the clients. The other one is the contractual employment, is where the employer directly employs the employee, but it is not a permanent employment. It is an employment by default for a fixed term. That is fixed term contract, fixed term employee. So only they are eligible, irrespective of the thing whether they complete 5 years or not. If they put in 1 year service, they are eligible.
Yeah, it's a great clarification. I think there are a lot of questions around that. First of all, what is the difference between a contractual employee and a fixed term contract? And what you're saying is that the contractual employee will not be eligible for
No, not
gratuity.
contractual. Sorry, Mr. Contract labor is different. Employed way. Contractual means it is the employee contract of service with the any employee who is employed by the company directly for a fixed term is eligible. Any employee who is employed through a labor contractor is not eligible for that 1 year concept doesn't apply.
Got your point. Okay, makes sense. And just a tricky question here. For example, a contractor is supplying manpower to a company, and the contract with the vendor and the company is for 1 year. And that vendor also signs a fixed term contract with the person they are supplying. In that case, that particular fixed term person will be eligible for gratuity from the vendor. Is that correct?
Yeah, it is a very good question, because mostly in the case of ITES, they'll be having the vendors. Some work at their office on the project, some work at their office of the client where they work. And to avoid, because they are not certain how long they will be having this project. Once if the project is over, they'll employment cease, especially for the ITES, because they are and they will not also, the vendors can't afford to have the bench strength unlike the big companies.
Yeah.
So to avoid the liability, they will be appointing them. So definitely for him, he is a fixed term contract employee. He is employee liable for payment of gratuity for 1 year or 2 years, or because he is fixed term employed. And here the question is not employed directly by the company, employed by the vendor or a labor contracting for a particular period of 1 year or 2 years fixed term. Then he is eligible for the gratuity without he putting in the 5 years of service.
Yeah. And RK, I'm getting so many questions. So I think let's take some question from our audience as well on this. And there's a question from Kirti Mathur, and she's asking, what about professional hired on work orders? Are they eligible for 1 year, like gratuity after 1 year?
Yeah, especially for this ITES companies, again, the thing is there will be freelancers. They will be
Mhm.
hired on the project basis. And the
Mhm.
consultants, they will be hired on the project basis. Or some consultants are hired on a fixed term. They may not be coming and working in the office, but they will be working it. But in one of the judgment, what they said that whatever nomenclature you use it, fixed term or whatever it is, a consultant or anything licensing, as long as that particular person exclusively works for your company and doesn't work in, and where you also put in the consultancy contract, non-competing, non-doing, not entertaining the works of the similar in nature and other things. So he is still deemed to be an employee. Of course, that is now open for the interpretation because the legislators might not have thought these many types of employments. That is why they did not put it. But certainly, when it goes to the judicial scrutiny, as per the judgments that have been principles laid down by the various courts, the consultant or a freelancer who works exclusively for one company, yes, for 1 year, he is also eligible. But if he is having multiple clients working for various clients, then he is not.
Got your point. All right. Before we move on to more questions, so many questions coming up. Before we move on to more questions, um, I think I asked audience to mark their attendance. I'm sure many of them have already marked their attendance now. So I'm taking off the barcode from the top to mark your attendance now. I might flash it at the end of this webinar one more time. But what I want to flash on the screen right now is that to our audience, in HR Success Talk, we have a group or a club called Future Leaders Club. And this is a club of the HR leaders who are basically team leads, senior team leads, managers, assistant managers, deputy managers, and senior managers. If you want to be part of this group and this club, I am now putting a new barcode on the top right on the screen, which you can scan and you will be able to get a form that you can fill. And if you qualify to be part of the club, HR Success Talk team will be adding you to that club. And through that club, you will be able to find a lot of opportunities to find mentors, to get knowledge, to attend HRST exclusive events. So there are a lot, and this is a all India level club that you can join. So I'm leaving it on the screen for a while, and please feel free to scan and register yourself for the Future Leader Club. Now, moving again to the questions that we have coming up, and there's so many questions coming up, and let me ask, and I just try to put some of them on this. This is an interesting one from Sapna Madan, and she's asking RK, if the contractor did not pay the gratuity, because we are talking about gratuity here, is this the principal employer liability now to pay for it?
Yeah, it's a very good question and the hot topic. And different courts have given different interpretations about it. And Supreme Court judgment is yet to come. And some of the High Court said that the gratuity doesn't come under the definition of wage. Therefore, the principal employer is not liable. The liability of the principal employer is only in respect of the wages that are otherwise payable by the contractor. One judgment of the Supreme Court, what it says is that the principal employer liability is only for the wages that are agreed under the contract between the employer and the principal employer and the labor contractor. I think it's clear. And the third thing is that recently the Calcutta High Court and the Delhi High Court and as well as Telangana High Court said principal employer is also equally liable and responsible for payment of gratuity. So the principal employer until unless decided. And it is when different versions are there, each judge or each person is at liberty to take interpretation. Mostly the labor laws are interpreted more in favor of the labor wherever there is a possibility. So we have to take ultimately the principle. Even otherwise, logically, if you look into it, when the contractor will be taking certain commission for supplying the labor, from out of the commission, if he has to pay the gratuity without he charging the principal employer, where from he will play here. So to ensure that. Another thing is that no one need to worry about it. Earlier, in only in some of the states, that compulsory insurance scheme of the group gratuity scheme is there as mandatory. Now, under the new code, they have introduced this compulsory insurance. And before onboarding the contractor, you have to ensure that the contractor has obtained the group gratuity scheme, and that the group gratuity scheme will take care of the gratuity. Neither principal employer need to worry about it, nor the contractor is there. So you have to, as a due diligence, while taking the contractor on board, you have to take care of it.
Awesome, RK. And I think one thing you mentioned was very key, that in the law that is passed, think, there is not a mention of every different kind of employment arrangement that an employer can have with. I think not all that is mentioned. But at the same time, I think there is a key point that you mentioned. Let's say if there is a consultant who's basically working only for a particular employer and not with everybody else, then I think the sentiment there is that this person should be considered as a fixed term employment with you, because he's not working with all of that. And keep in mind while deciding on the person gratuity after 1 year. Is that correct understanding?
Yes, yes, yes. Though you write all the conditions in the terms of the contract, there will not be any relationship of employer and employee. You are an independent contractor. I am the principal. You are the agent. Blah 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 blah. Whatever it is, but when it goes to the judicial scrutiny and interpretation, they will rely upon the precedents and they may interpret it.
Makes sense.
And any
RK,
contract should be in consonance with the provisions of law, but not in violation of whatever we put may not be binding. There are negative covenants also.
yeah. RK, we have a question from our YouTube audience right now. I think if his name is Nupur, I believe. The question is: does consultants fall under gig workers?
No, it all depends on the nature. Any individual contributor fall under the definition of worker irrespective of the salary, because he will not be having any powers of supervisory or managerial in nature. And another thing, under the new wage code, everyone is a worker, even including the general manager and vice president. Now he can sue the employer under the wage code. For the
Interesting.
and that wage code, now the definition also differed one act to the other act, where the ID Act more or less under industrial relations code it remains same, but in the wage code everybody is an employee.
Got your point. Okay, we have one question that is, I also want to know the answer of this, RK. This is a question on gratuity and not necessarily connected with the new wage code, but something that a lot of HR people still struggle. And basically, RK, that this question is from Bane Bankatesh. And that many employer put gratuity in the CTC, right? While we are showing the CTC,
At the threshold, I answered it. I would answer once again.
Yeah. So what if I, as an employer, has placed gratuity as part of the CTC, and now the employee leaves the organization after 3 years, let's say, right? The person has not completed 5 years, or let's say 4 years, 8 months. So law-wise, he's not eligible to get the gratuity. But mostly employers said that, but this is part of my CTC, right? I'm supposed to get it back. What is your opinion on that?
Yeah, because this is a contract between employer and employee. I don't know why the same talent acquisition team or HR team following the same old trick, and now everybody is wise now. They are far ahead. Whether though they are poor in mathematics, they are very good in knowing the salary, how it is offered. What I mean to say, bottom line for the employer is the CTC, for the employee is the take home pay. What they get to their pocket is the important. What I mean to say is that there is also judgment, because the gratuity is a contingency only if you put no, for the fixed term contract you can put it as annual pay, because as part of the CTC, because by default after completion of 1 year you get, where for the regular employee If you put that gratuity will not be treated and adjusted against the statutory gratuity. This will be treated as part of the payment you are paying in the name of gratuity, but that cannot be treated as a gratuity because it is. However, you can't escape the liability because the employee says that the total 25 lakhs annual package they have mentioned in the offer letter in the annex or wherever it is, and that includes. Same is the case with the bonus. Normally, they also pay the bonus. So, if it is a non-statutory bonus, that is a different thing, performance bonus, etc. If it is a statutory bonus, bonus is also until unless balance sheet is finalized, set on and set off or allocable surplus is finalized, you will not be able to know what is the percentage ranging from 8.33 to 20%. So, if at all you got to pay, you have to pay advance against bonus, and after finalization of the accounts percentage, you set it off balance to be paid.
Yeah. Okay. Is there any verdict from court on similar cases where gratuity is part of CTC and
Yeah,
employer has?
there is a recently verdict. It has to be only paid upon completion. It can't be annual. If it is said that cannot be adjusted against the statutory bonus.
Got your point. Okay. So hope Venkatesh, your question
Because
is
mostly
answered.
it is being carried out in many of the letters because they are not updating their appointment terms depending on the law that is changing from time to time. They are carrying like a Woodward's Grape WhatsApp advertisement. Why baby crying means so generation it passes on. That is the thing. One has to periodically look into it and update, otherwise it will become an absolute. And there is one more query that has come freelancer, then would they still be eligible for the 1 year? Yeah, that has been answered. You just can see, Mr. Goyal.
Yeah. I was about to say this has already been answered. As long as the consultant is full time working with you, it is. If it is not, then it is not. Okay, great. There's so many. Oh, sorry, I just clicked on the wrong one. Hold on. So let me pick one more. Is there a possibility?
This is also
Well,
been answered.
this is an interesting one. DKS, Deepthi KS, and I call her DKS, is asking interesting one because you know that you need to pay gratuity after 1 year, right? So what if the fixed term contract is drafted for less than a year?
Yeah, for 6 months and all, not because they have said 1 year, 1 year. But again, if you put it for every 6 months, if you renew it, when it goes to the court interpretation, only to avoid the statutory liabilities, they have paid like that. If he is employed only for 6 months and then let off, that is a different thing. Because they simply not said all fixed term contract employees are eligible for gratuity. They have said the fixed term contract employee who works puts in 1 year contract service, then he is eligible.
Yeah, I think there's a similar question from Jagadish Alu. If any FT employee worked
Even if he
11,
works for now, normally the continuous service in the gratuity is defined act. So 1 year what they say is not completing 12 months, 365 days, so on and so forth. Like an employee puts in 4 years, 240 days or 6 months or more, he is eligible though he has not completed 5 years because in the fifth year he has completed the year as defined under the Gratuity Act. So by working for 11 months, 29 days, 1 day less. No. Even for
awesome.
any person, because I will always say management is nothing but common sense. Common sense is most uncommon. Law is nothing but logic.
I'm sure about that. All right, we'll take a little bit of quick break from the question and answer. So many going on, and I would like to put attention of the audience back on the barcode that I placed on the top right. This is the barcode of Future Leader Club, and anyone who is a team lead, a senior team lead, assistant manager, deputy manager, manager, and senior manager can definitely scan the barcode, register to join our Future Leader Club. And I see on the comments, some people are asking, is it for Elite Club? Well, first of all, let me take down this barcode from here, number one. And now let me put on the barcode for Elite Club. Now, what is Elite Club, first of all? Elite Club is a club of HR Success Talk where we have all the senior HR leaders who are basically part of this club. This is a city-wise club, which means that this club has presence in multiple cities. To be specific, we are present right now in 13 cities. which is Delhi, Faridabad, Gurgaon, Noida, Mumbai, Pune, Chennai, Hyderabad, Indore, Tri-City, Dubai, Bangalore, all these places we are present at this point in time. So I'm putting the barcode for joining our elite club on the top right. So, but please remember, anyone who is above senior manager should only scan, not the person who is senior manager and below. For those, we have future leader club. So, if you are a director, senior director, AVP, VP, CHRO, general manager, senior general manager, deputy general manager, all these kind of people in the HR role definitely can scan the barcode and apply for it. Our team will review your case, and we'll be sending you the invite to join our club. There are people asking for the attendance barcode. I will flash it again after during the end of this webinar. So be there. I'll definitely flash it there at that point in time. Now, so RK, coming back to all the questions that we are getting from our audience. Right now there are almost 300 people on the LinkedIn. There are a lot of people on the YouTube also, RK, who are joining us, and the comment box has not stopped. I'm not sure which one not to pick, but I'll try my level best that while speaking, I'm reading and also trying to figure out whether this is the right question that we have for you. There's a question from Jaspal Negi. Again, a Negi to Negi question for you. So his question is: employers are keeping gratuity, PF, ESI as part of the CTC for permanent employee. Is this legally correct? How new code is dealing with this?
No, it is the same thing, because in the new code they have categorically said that the old provisions, the principles of law that has been laid down by the court continues to apply even under the new enactments. So automatically I have answered as per the gratuity is concerned. Even if you put it, it will not be this thing. Only after 5 years they will be getting. And in the event, as you have rightly put a question, that if the employee leaves after 2 years, you can't recover and the amount of gratuity, or otherwise the employee also can sue now to recover the gratuity. One more thing, I don't know, any question has come in that aspect, very important. All the participants pay attention and make note of it. Now under the new code, the final settlement has to be done within 2 days from the patient, from the date he is relieved. If you delay, the employer can be prosecuted. And as per the existing law, I mean the repealed act, farmer labor laws, if the employee got to prosecute the employer, then he has to make an application to the labor department, and the labor department official, by giving notice, then only he can prosecute. Now under the wage code, the employee is conferred with the power directly to prosecute the employer. And suppose in the event if any such payments are not made, he has two options. One is to file an application under the wage code for recovery. The other one is violation of the gratuity act or whatever it is. He can also go for the prosecution. That is why the employers has to be cautious now in respect of this particular payments, F&F settlement and other things.
Yeah, RK, I think Sadhu Sharma has read your mind. He has exactly the same question, that how even it is possible to do these clearances in 2 working days. And I'm sure, I don't know, RK, you can put your opinion on that.
I can mostly the ITES once again here the face industry. Some of them will be having the company property, mobile, laptop, or something like that, and they don't return it. They will be sending the sweet mail through email that I am resigning, and he will be demanding the payment and other things. So the company is looking, when he places the paper 2 months or 3 months or 1 month, as the case may be, then you can ask him that the date, by such and such a date you are required to clear everything, and then you will be relieved, because your liability arises only after relieving. F&F arises only after relieving. If relieving is not done, F&F doesn't arise. The mere resignation is 3 parts. Resignation is the first part, acceptance is the second part, relieving is the third part, F&F is the fourth part. There are so many steps in it. You have to follow the steps.
Got your point. And if the audience
each step, if you correctly follow, that will take you to the altitude.
All right. So Okay, I'll pass on this question to our audience because this is something maybe they have some softwares or whatever to make sure that the FNF is processed
Yeah,
faster.
this has come. Do the contractor need to pay gratuity the previous years also? Or no, the gratuity is payable only for the employee. Normally the contract labor system they are going is like men may come and men may go. What was said, contractors keep changing, the worker works forever under different contractors. It is the principal employer's liability in view of the recent judgments of the courts that the principal employer is also liable for payment of gratuity to ensure the outgoing contractor settle all dues, including the gratuity, then only onboard these employees on the new contractor.
Awesome. I'll not flash the question on the screen now because you are taking the question without me asking them. So I'll
Oh,
not flash.
sorry. Now I allow you to do your rule.
Okay.
Right.
Yes, some great, interesting question. And there is a question from Sriti Sharma, and she's asking there is a provision for overtime beyond 8 hours per day, right? Does it cover all the employee, permanent, white collar? What is your opinion?
Does it cover? Yeah, overtime is for everyone who works. And one thing what I mean to say is that this Factories Act or Occupational Safety, that act applies only to the factories, not to the. For as far as IT, ITS, commercial establishments and service sector, it is the shops and establishment of the respective states that continue to apply. This will not be applicable. Another thing is that overtime is there even under the shops and establishment, even under the new acts, and if they work beyond 8 hours, they are entitled for the overtime at the rate of double the ordinary wage. Be it a
Got,
permanent, be it a contract, be it a contractual, or whatever it is.
got your point. There is a very particular example. Again, I think there's so many negis on this right now. And this is a
Yeah.
very like mathematical question that is for you. You can read it out, and I think our audience can also read it out. It's basically about what will be the PF.
No, you have to take it special elements, whatever it is, total is 1,50,000, you have to make 75.
So your basic has to be 75, number one. If the basic is 75, what should be the PF RK? I think what you're going to say
PF liability is only up to 15K, as I said, until unless the employer and employee voluntarily opts for the higher contribution.
yeah. So what you're saying is that
And the department cannot ask you to pay on 75K because
yeah,
15K is the liability.
yeah. So basically the liability is 15,000.
Yeah.
Sorry, the capping on 15,000. But if the employer has the policy to give on the actual basic, then this is between employee and employee, is what you're saying, right?
Yes.
Okay.
Mostly the myth here is everybody is thinking the actual wage they have to contribute, though it is beyond 15.
Okay. There's one question from our YouTube audience. And the question is, in that case, the gratuity payable till retirement age or till the time the person has worked?
No, even if the employee works beyond for gratuity, unlike PF, there is no question of retirement here. As long as he works, even if it is 60 or he gets retired at 60, you re-employ him. So you settle everything at 60. Then it is a different thing. If he works after retirement for 5 years, he will get. Or else, if you take him for a tenure, in most of the companies, the retired employees are hired on a fixed term contract. Then they are entitled for the gratuity even if you employ them on a fixed term contract. Even if he is of the vice president or general manager rank, because under the new wage code, there is no distinction between these things. So they have to be paid, even if the thing is that. That's what.
Sorry, I think the question, RK, here is that if there is a death of the employee, should
Death of the employee, that yeah.
should it be paid till retirement, calculating the gratuity till retirement, or to the time the person has worked?
No, not required. Only till the time he dies. Only the death is normally mentioned because the completion of 5 years is not necessary in case of death.
Got your point. There's a question from the audience for the video recording of this particular webinar. I wanted to tell the audience that the video is definitely available on YouTube. You're watching on YouTube anyways, your YouTube audience. It will stay on the YouTube so you can watch any point in time. It will also stay on our LinkedIn page so you can watch it there as well. So no problem. We don't have to send you separately. You can go to our social media pages and watch it. All right. So I'll give you a break, RK, because I know that you're speaking since long. So I'll give you a break. To our audience, this is my favorite and personal request from all of you. There are almost 300 people on LinkedIn, and I'm sure more than 150 200 people on YouTube at this point in time. HR Success Talk is a community that serves HR leaders and try to make an impact by sharing different kind of knowledge with them. And we would love to have your support. Right now, I'm putting a barcode on the top right where I am requesting all of you to share a Google review about HR Success Talk on Google. So please do go and scan the barcode. I would request HRST team to also share the link of this barcode on the chat box and also on the WhatsApp group for everyone to go and please share your experience with HR Success Talk or your experience here with this webinar. Do give us a 5-star. I'll definitely like to have a 5-star there. So do give us a 5-star there. Looking forward to that. This encourages us and our team to bring such kind of webinar more for you. So I'll keep the Google review form, Google review link on the top right for a while for you to scan and give your reviews. And you can also keep an eye on WhatsApp and chat box to have the link. So RK, I think enough of the rest for you. So, so I will now go ahead and take more questions. This is a very interesting one. Again, from the YouTube that we got, Ravi Gangwani is asking, what are the steps to do? We have to wait for the state circular to release for reinforcement? Like, this is a question, right? Do we need to act? Do we need to wait? What do we do?
Now the Central Act is concerned, the wage codes have already came into force. Almost all states, barring about 3 or 4 states like Tripura or West Bengal, some of the states haven't yet framed the rules. Where the rules are not framed, the provisions connecting to the rules will not come into force until unless the rules are finalized. Where the rules have already been framed, draft rules, now the central government is going to call objections over the draft rules. They will be making a final draft rules after a 1.5 month or so, maybe by end of March or February. And afterwards they will publish the rules. Then they will be notifying it. All this, the 3 months time will be taking place. Maybe perhaps it is only a guess. From 1st April, it may come into the force where the state governments have framed the rules.
RK, somewhere I read that if the state government is not able to frame the rule, let's say by the deadline, the central law will be applied straight away. Is that correct?
Now, the central law, to the extent where it is not, suppose ESI is there, no state government rule is required. EPF is there, no state government rule is there. Even in the Bonus Act, certain of the provisions does not require rules. Certain of the provisions only require rule. So wherever there it is not linked to the rule, it automatically by default apply. It came into force already. The PF1, because old acts are no more in force. Just even if the state do not adopt, they will be nowhere because old acts have been repealed. After repealing those acts, only the new enactments have come.
Got your point. Okay, another interesting question from LinkedIn. Vishal Watekar is asking, do we need to have annual variable pay as part of the calculation for 50% basic?
Annual variable pay as part of? Yeah, that variable daily allowance. No, annual variable pay which you are paying will not be the part of the basic because it is contingent. It is paid. Suppose if it is paid monthly, also certain companies they put it annual, but they add because sometimes to the monthly pay also.
Got it. So it means the variable annual pay will not be part of calculating 50%. Okay. Well, I think we know the answer of this, but still we ask you, RK. Rashi Shrivastava is asking, is the company liable to pay gratuity to employee even if it is not mentioned in the appointment letter?
It is a statutory obligation. For a statutory obligation, no need to have a contractual contract that they will pay. If they mention in the appointment letter or not, they are entitled for it.
I think makes sense. Now I'll switch a little bit on the health checkup things going on right now, right? Where the
Yeah.
law says that company
The,
having
yes.
employee more than 40 years has to go through the checkup. Throw some light on that particular one, RK, and then take the question from Ravi Gangwani on that as well.
Yeah, anybody who has put in 40 and more years of age, not the service. I think nobody may be putting in the service. Don't get confused. It is the age, not the service. Then they need to be sent for the annual medical checkup. Be it a permanent worker, contract worker, contractual employee, fixed term contract. It applies universally to all the employees. You have to refer him for the medical examination. There the challenges comes, suppose in the medical examination, if you found certain of the things, and if you found that is not medically fit, you can invite the medical discharge of the employees on the medical grounds also. That is, it has to be done at the cost of the employer.
Got your point. Let me take a question from Lena. I think you kind of touched upon this, but let me ask it again. What if the contract for 11 months and then break for 6 months and then again 6 months? And I think you already answered that.
That has been
If,
already answered.
can you say it again for
The
Lena?
same thing that justice not only be done, it should seem to have been done. The clause not only be put, the purpose behind, the intention behind of the clause also will be taken. So it will be, suppose if it goes to the judicial scrutiny, the judges definitely would opine, because labor interpretations, labor laws are liberally interpreted towards the workforce than to the employer. They may have a definition, but earlier also there are certain judgments on the same principle, giving the artificial breaks shall not be considered as a break in service, it is a continuity in service.
Makes sense. There's a very interesting question here, RK.
I think more on the law, more on the flaws they are having doubts than the laws. Just in the light I'm putting it, participant don't think otherwise.
I have one interesting question. I don't know who that person is. It says LinkedIn user, but I'd never heard of that. But I'll still put it on the screen here for you. What about the clause where they mentioned that the employee can hire police to resolve the issue of the company? Is that correct? Have you heard of that?
No, I am also first time hearing out of my 39 years. Employee hiring the police. They mentioned that the employee can hire police in all to resolve the. No, employee means like outsourcing the employee problem to the police. I couldn't get it properly until unless they are so clear it.
Okay,
Issue
so I
in
would
the company.
request.
No, actually, the thing is that if it is a criminal offense, no need to put in the clause. They can as well file it. Police will take. If it is not a criminal offense, the police are not supposed to involve in the civil dispute. That is what the Supreme Court time and again said. It is a civil dispute, not a criminal dispute.
Perfect, makes sense. There's another question on the apprenticeship here. What about the apprentices hired for 1 year?
No, they are not, because apprentices are again different. Some apprentices are those who have been referred and doing the apprentice as part of their academic curriculum. When they are doing it as part of the academic curriculum or as they are doing for the apprentice scheme under the Apprentice Act, they are not entitled. But in most of the companies, what do they do is, because there is a cap on the engaging the apprentice percentage under the Apprentice Act. But in any company recruits out of 500, 400 workers as an apprentice, and they have to pay for a fixed term, like 3 years apprentice, they have to pay. If they are engaged under the apprentice scheme, under the Apprentice Act, need not.
Awesome. Okay, let me scroll down more. I think I'm just trying to see. Well, I don't know what does this mean, RK. Maybe you know that. Satya Kurukri is asking, is the gratuity comes under FFS? What is FSS? FFS.
Full and final settlement. Yes, full and final. But that FFS is normally SMS language. WhatsApp language.
I call it FNF, full and final.
Okay,
Uh,
they has extended the full meaning in it, the land was spent. Full and gratuity, we have 30 days time to make the payment gratuity from the date of this.
Okay. Here's another one from Krishna Kumar. And the question is, are there any additional benefits, social security or welfare provisions under the new code that specifically benefit PWD employees? I think it's a physically challenged, right? Employees. But yeah.
PWD means Public Works Department, or it can be physically, I don't know what exactly is that. But it is applicable to all. Special benefits, no.
There's
Whatever
nothing
it is
special.
there. Yeah.
Okay. Let me just see. I think a lot of, by the way, a lot of questions are there. People are asking like about the challenges of, they're telling on the comment box that the challenges of clearing the full and final in 2 days that I can see. A lot of
Yeah,
people
yeah.
are,
Now, what I said is that I have already clarified because the resignation, acceptance, relieving, and then the final settlement arises only after the relieving accrues the right. But by the same time, you cannot hold the relieving forever and not paying the way because he has to join elsewhere. Another problem is that if you hold the relieving, he continue to be on the rolls, you have to keep paying him. ऐसा
yeah, that's
कुछ नहीं है and there is no such thing like लगे रहो मुन्ना भाई.
yeah, I think, but at the same time, RK, I think it's too much harsh on the employer to say clear the full and final in 2 days.
I quite understand, but the thing is that they'll also, because the employers also has to make a representation to the enforcement authorities or the government, they have to take it or it has to be challenged because some time is to be given and other things. Perhaps at the time
Yeah,
of making legislation, the unions might have demanded, they have incorporated it because the government, even after retirement, yeah, such things takes place. But law is law. What to do? Until unless it is amended, we have to comply. The challenges they will not come into the play.
yeah, I think you're right that the lot of employer association will still have time to go to the government and say this will be difficult. I think there has to be a timeline given
Yeah,
post all
that is
government.
that is ignored because even any act before finalizing the act, they publish the draft, invite the
Yeah,
objections. That time also, the people did not take interest to go through the draft and raise objections, express difficulties.
awesome. I would like to bring so we are shifting gears, RK. I'm now going to a different aspect of the new wage code. And before I do that, I would like to request all the audience to go and just scan the QR code there on the top right to go to the Google review, share feedback about this event, give us 5 star. Looking forward to that. Now moving to a little bit different tune, RK. There is a question from Kumar Anshuman, and the question is about provision of working 12 hours per day for 4 days in a week. Um, but it does not comply with the day limit of 8 hours. And I think 8 hours is something that was the old rule that we had. What do you have to say on that?
Yeah, but when it comes to the manufacturing, it is okay under this new enactment. 12 hours you can take. However, the weekly hours remains the same as per like that of the old act. 48 hours it should not cross. Instead of working 6 days at the rate of 8 hours, it is for. Suppose the moment the 48 hours the crosses, they are entitled for the overtime. They can be 10 hours. But however, in the shops and for the IT, ITS and service sector, it is the Shops and Establishment Act. But certain of the states amended to that of 10 hours, or some of the state some of them are still maintaining 8 hours. So that the new enactment will not come into play for that. Is not
Awesome.
only it is applicable to the manufacturing industries.
Yeah. Okay. There's a question on leave encashment. Long question from Annapurna for us. Long
Yes.
question, but I think end of the day she's asking is, tell about the leave encashment. Can we pay every year, or we only need to pay at the end of the year, end of the employment? What is the max allowed calculation on basic DA last drawn? So over to you. lot of questions in one question.
Yeah. It is a fair enough. I know, madam, also. And the thing is that the leave encashment under the Factories Act, that now the OSH, Occupational Safety and Hazard Act, the new code. Earlier, only 30 days were there, and that too only at the severance of employment, the leave encashment to be paid. But under the Shops and Establishment Act, in Telangana and some of the states, leave encashment is an annual basis. The maximum accumulation as per this Shops and Establishment Act of this particular area is 60 days, and under the Factories Act, there were now they have introduced in the new enactment leave encashment annually also. So whatever the leave that the balance they can encash it, it is annually. The other thing is that whether it is mandatory or not. In anything whichever mentioned in the act, it is a mandatory. Third thing is the payment to be made on the gross or basic or whatever it is. The leave encashment has to be paid as per the gross wage. The reckoning point for payment and the base for the payment is the definition of wage under the Shop Act, definition of the wage under the new code also. So it is the gross pay that has to be paid. But normally I do get questions from some of the HR professionals, X company is doing, Y company is doing, why can't we do it? Because what X and Y follow is not the law. What is envisaged under law is law we have to follow. That is
Correct.
the flaw what they are doing it.
Yeah, I think it is important to just go to the law and read it as opposed to
Yeah. Yes.
going by what your other fellow colleagues are doing.
Yes.
Right, wrong thing. I saw an interesting question. I don't know where I missed it. Hold on. Yeah, this is an interesting one. This question is from Swami Chakrabarti, and Swami is asking, in case of the intercompany transfer within the group, does a change in the employee code affect the employee gratuity?
The thing is that it all depends on the terms and conditions of the appointment. At times there will be amalgamations, there will be mergers, there will be acquisitions, and certain times where these things are there, the transferee settles his account, then the employee gets transferred to the transferor settles the account, then the employee gets to the transferred to the transferee company. But in the case where there is a group of companies, he is appointed in one company and works for several companies. But the thing is that as per the appointment, until and unless there is a break in service, the civilians, wherever he works on behalf of that company, be it a sister concern, subsidiary or group, is still once completing 5 years eligible for gratuity.
So he will be eligible for gratuity.
Otherwise, he will be shifting every year in one company.
Correct. We have a question from Sahil Rastagi, and he's asking, does the overtime rule apply to all the employee respective position in the grade?
Yeah, it applies to all the employees, but not for the senior positions.
What does it mean? Can you explain a little bit on what the senior positions mean?
The worker category, whoever comes under the definition of employee and worker under the new code, the definition of employee is there, definition of workman is also there. Earlier under the old enactment, the definition of employee was not there, and it is applicable whoever is not the individual contributor, who are not discharging the supervisory and managerial functions, then they are entitled for the overtime.
Got you, man. There is a question from Anjali Sasteva. She is the head of the HR of Globe Dental. Her question is whether the performance-linked incentive, whether paid monthly or annual, part of the allowance for the purpose of CTC, or it is over and above CTC. I think the question is more about the basic calculation that we are doing. What is the question here? What is your answer?
What is performance-linked incentive?
Yeah.
Performance linked incentive is normally cost to the company. CTC company only has to pay. That any payment that is to be made and offered as part of the CTC. Another thing is that mostly the companies will be doing mistake that the performance link they should not put any amount. Or they should also make a policy parameters that if you reach to this many points, you will get this much, or if you reach to this many points, you will get this much. Otherwise, they will be say ranging from 1 rupee to 1 lakh rupees, depending on the performance. How it is totally ambiguous. Depending on. And another thing is that some people normally the appraisals takes place here, for example, January to December or September or whatever it is. The increments are released, but performance link in the performance pay is released after 6 months. Suppose in the event before this period they leave, they say will not pay. but you are paying the performance pay for the past service, not for the future service. He should not be deprived. If he goes to the court, he will be ended. Another thing is, if the employer so wants the performance pay, he has to define the performance pay. The performance pay is not only offered for the service in the past, also a motivational pay to continue to show the same performance for the coming years. Suppose in the event if you leave, you will not be entitled.
Yeah, and but at the same time, RK, this particular PLI will not be considered for that 50% basic wage. Is that correct?
No, it is the annual pay. If you pay it annually, no. If you are paying monthly, then it will go.
Got your point. Okay.
Annually, a lump sum amount, no.
There is a question from Vijaya Kumar, and he's saying, is the appointment letter applicable for all category?
Yes, now under the new law, even old law also it was mandatory. Now it is highlighted. Earlier it was not highlighted. That's all. Everyone has to be given appointment letter. Even the contract labor, fixed term contract, anybody else. I don't know. Normally the employers are under the myth that if you don't give appointment letter, when you are covering them under ESI, EPF, everything, that recorded evidence will be there, employer-employer relationship. It has to be given under the new code. It is mandatory, otherwise it is a violation.
Perfect. Very clear. We have a question from Nupura Gunthe, and she's asking, does all the freelancer and consultant who work full-time fall under gig? And
No,
do we
gig workers are different. They are unorganized. A consultant is working sitting at a one particular place. Gig workers are Swiggy workers, Zomato workers, and the delivery boys. All these people are called as the gig workers, and for them now they have got a special enactment for certain benefits. The freelance consultant is a consultant who sits at home or at his office or from remotely he works or whatever it is.
Perfect. So let me see. This is another interesting question from Manisha K. What about the retention bonus that we pay on monthly basis? Do we need to consider for calculating 50% basic?
Yeah, that has to be taken.
Okay. Let me see something
Category
from.
bonus is exempted.
Mhm. Okay. This is not a question right now from the audience, RK, but this is a question that we got during our webinar registration time. Can a checklist be provided for implementation? Well, I don't know whether checklist is ready right now or not, but do you have any checklist that you can share with
No,
the?
anything for everything enactment, there are the things. The checklist can be what is to be complied is a checklist. Not complied is. So we are not providing any checklist now because a referral of the acts will know what to complain, what not to complain. The act only speaks to complain, not to complain.
Perfect. All right, let me see. Oh my God, there's so many questions. Here is this. Should apprentices be included in the annual health medical check? Well, if I don't think any apprentice will be 40 years old, right?
They might be the lateral apprentice, like fresh hires and lateral hires.
So Anjali, I think the point is that
Yes,
the
sir.
person for a mandatory one, it has to be 40 years and
Yeah.
above. And I think
Everyone.
we as apprentices won't be that. So yeah. Well, this is a different kind of question from Sadi Hussain. Are third-party contractor eligible for leave?
Yeah, everybody they are also covered under the contract labor regulation, which is under the new code. Also, it is there. They are the contractor is principal employer for them, and for us we are the principal employer for the is immediate employer. They are eligible for the leaves, overtime, gratuity, all other benefits.
All right. I'll take one more question on the leave with pay. This question is from again Vijay Kumar is asking, can we pay leave with the wages to a contractor worker instead of leave? So we don't want to give leave, we want to give leave with the wages. Is
No,
this
leave
okay?
is a mandatory. It is the right of the employee. If he wants, If he avails the leave, of course, sanctioning or non-sanctioning is under the prerogative of the employer, depending on the exigencies. But you cannot say, "I will not give you, only give you the cash," because it is regenerating. It is to meet the contingencies. It is to meet the needs. You can't deprive him of the leave. That will be a prosecution, even if you pay the wages. Suppose if he doesn't apply, if he makes an application for employment, that is encashment, that is a different issue.
Makes sense. Okay. So we are coming closer, RK. Still, there are a lot of questions flooding
Yeah,
right now.
only 10 minutes is left.
Yeah, we are coming very close. So, team, we are coming very close, so we have to close. But let me take some quick questions so that we can cover as many as we can. RK, the question is on your screen.
Can we just provide offer letter or a separate appointment letter should be given? Actually, the offer letter is meant is a provisional appointment that conveying your acceptance to appoint him so that he can place his papers with the present employer and join you, so that tomorrow one should not say that appointment letter you will be giving at the time of onboarding with all the details, terms and conditions. So offer letter is different from that of the appointment letter, but nowadays offer it, the nomenclature for the appointment itself is changed as offer.
Okay. There is a question from the YouTube. The Swati is asking, how will overtime be calculated as per the new? Is it double the
It is
rate,
on
right?
the gross wage, it has to be calculated, not on the basic wage. It is at the rate of double the ordinary wage. Suppose I get for 8 hours 8 rupees, and out of which 50% basic, 50% allowances, you can't compute the overtime on 50 rupees. It has to be on the 100 rupees per hour. How much it comes? Double the ordinary wage. Almost double. Suppose per hour, if it costs in the regular employment, regular wage, 5 rupees, for overtime it is 10 rupees. It is that simple as that, simple arithmetics.
Awesome. Now I have one very interesting question. That is a question that I also have, RK. I face this situation a lot. Maybe you're the right person to answer this question. But before we flash the question on the screen, my last request from all of you to please go to our YouTube, go to our Google review. There's a QR code on the screen. Please scan it. As I promised that I'm going to share the attendance QR code as one more time on the screen. So I'm taking off the Google review one. I'll request my team to share the link on the WhatsApp and the chat as well, so that if anyone who has not filled the Google review can fill the Google review from there. But for last time, I'm putting the attendance on the top right. So please go to this QR code, scan it, fill the form, and you will get your certificate within a couple of days after the webinar is over. Now, RK, the question that I also have is the question from Devanshu Gupta. And the question is, for employee working in multiple state, remote and field role, which minimum wage should be applied? Location of the employer or location of the working activity?
It's in a remote place. No, it is the establishment address that is to be taken, because that law only applies, not at the place where he works remotely.
What if, RK, I got your point. So it's the employer address that matters and we follow that minimum. What if the employer has multiple offices? I have one office in Delhi, another one is in Chennai, let's say.
Wherever his principal place of employment. Suppose I am appointed at Delhi and he has been deputed or for some time sent Gurgaon or Pune or Hyderabad or Bangalore, wherever the IT offices is there. Suppose if he is permanently employed over there, that suppose temporarily if he goes for a 1 or 2 months on deputation, the Delhi wage applies. If he is completely transferred over there, in the respective state, whatever the minimum wage that applies.
Perfect. And what if this person, let's say I hired five people in Chennai office, and in their appointment letter it says that their base location is Chennai, wherein my main office is in Delhi. For those 5 people, which minimum
Only
wage?
Chennai wage only has to be followed, law of the land.
Got your point. Great. Thank you very much. And I think we are very close. We are at least at
Yes.
5:24 at this point in time. And to all my audience, I know that you are still asking so many questions, but unfortunately, I won't be able to take all the questions that you are asking, and we have to close this conversation. No promises, but if we get lot many requests where people are asking RK to come back again when the law is fully baked in and there are a lot of clarity. And if RK agrees because he's very busy with his court cases, clientele, etc., etc., and if RK agrees, we'll be more than happy to have him
Sure.
back and serve us there.
Yeah,
RK, anything else you wanted to say at the end?
yeah, once if it reached the finality after completion of the rules, definitely we would look into it. And I thank HR Success Talk and as well as Mr. Govind for arranging and for the patience of the participants who I hope you are all, it is an accomplishment, not a completion. And if you want to give any feedback or your views, you can connect me with the LinkedIn, my LinkedIn profile with the same name, Radhakshnamurthy Madhiraju. And depending on the availability of time, I may be able to revert back to you. You can stay in touch. That is my by logging into my LinkedIn, getting connected through my profile. Thank you.
Thank you, RK. And to all our audience, first of all, thank you very much. You guys, you have joined today on Friday in the evening, and I'm sure you are closing your working day today. But this might be a very good, interesting conversation. I hope that many of your doubts are resolved today, and I'm sure there are many that you wanted to ask more. I would
Yeah,
request my
it is
team
a
to
wide
share.
subject. It is a wide subject. In fact, requires a lot of time. Yeah. Hmm. Yeah.
Awesome. I would request my team to share Radha Krishna Murthy's LinkedIn on WhatsApp and also on this chat so that you can find him there. And if he has time, he can answer some of your questions. As I said, that depending upon the request from our audience, if we can also have one more round of this conversation because I also found that there are a lot of questions which are not uh, generally linked with the new wage code, but there were a lot of questions which are general labor law questions that we had in our mind. So it could be a great opportunity to invite RG again, and I'm sure he will be kind enough to find some time for us to come on this
Sure.
webinar where he can answer a lot of questions for us and our audience. With that said, thank you very much, everyone. We tried our level best as HR Success Talk community to answer your questions and take an opportunity to at least bring all of you together and answer your questions. Hope we are able to do justice to this webinar. We will be hosting many such webinar every month on different topics. Stay tuned. Follow us on our social media, LinkedIn, Instagram, YouTube, and we will be more than happy to share the links of the events that we conduct, webinar or in-person events that we conduct all over India. With that said, thank you very much. Have a nice day. And once again, thank you very much, RK, for
Thank
joining
you.
me.
Right. Okay. Signing off. Bye.
Bye.